Stop scrolling, because what I am about to share with you in the next few minutes could directly affect your visa, your green card, your work authorization, or whether you are able to remain in this country. These are not rumors. These are not political opinions. These are real, documented changes happening right now. And most people do not yet have the full picture. If you have any immigration status, any pending application, or anyone you love who does, you cannot afford to miss a single word of what comes next. I'm Edward, and welcome to U.S. Green Card Signal, the channel that cuts through the noise and gives you exactly what you need to know, when you need to know it. I have spent years tracking every meaningful shift in U.S. immigration policy, and I will be completely honest with you. What is happening right now is unlike anything I have seen in a very long time. The changes are coming fast. They are hitting multiple systems at once. And if you are not informed, you could make a decision today that seriously damages your future in this country. Here is what we are going to cover: the sweeping executive actions reshaping visa processing and travel, the quiet but significant changes hitting employment-based green card applicants, what is happening to H-1B, OPT, and work authorization holders, the deportation policy shifts creating fear even among people with legal status, and perhaps most importantly, what you should actually do right now to protect yourself. Stay with me, because the most critical part of this video comes near the end, and it could help you avoid a mistake that cannot be undone. The big picture: a system being rebuilt. To understand what is changing, you first need to understand the strategy behind it. The current administration is not approaching immigration as a series of individual policy adjustments. It is treating the entire immigration system as infrastructure to be rebuilt from the ground up. Executive orders, agency-level directives, and reinterpretations of existing law are all being deployed simultaneously. That combination is what makes this moment so different from previous shifts and so consequential for everyone with immigration ties to this country. What is happening at the consular level? The first major shift you need to understand is what is happening at U.S. embassies and consulates around the world, the places where visas actually get approved or denied before anyone steps on a plane. In recent months, visa interview wait times have shifted dramatically in certain regions. Some countries are seeing faster processing as diplomatic priorities change, but others, particularly in parts of South Asia, the Middle East, and Sub-Saharan Africa, are experiencing new administrative processing holds that can last months, with no explanation provided and no meaningful appeal process available. If you are waiting for a visa appointment or are currently stuck in administrative processing, this is not simply a backlog problem. This is a policy environment problem. Understanding the difference changes how you respond and what options you pursue. Now, here is where it becomes more alarming. The administration has expanded the use of visa revocation, a power that allows the State Department to cancel a valid visa even after it has been issued. This authority has always existed, but its use is accelerating significantly. People have had visas revoked while traveling, while in transit at airports, and in some cases without being notified at all until they attempted to re-enter the United States. The legal basis being cited: national security and public interest. Two categories broad enough to apply to almost anyone under sufficiently flexible interpretation. If you have a valid visa right now, that is not the same guarantee it was 2 years ago. Please keep that in mind. Employment-based green cards, where the changes are deepest. Let me turn to something affecting hundreds of thousands of skilled workers and their families: the employment-based green card system. This is where the policy changes may be least covered in mainstream reporting, but most deeply felt by the people living through them. The administration has directed USCIS to apply stricter scrutiny to I-140 petitions, the foundational document of most employment-based green card cases. In practice, this means officers are re-examining cases that were previously approved, issuing requests for evidence on applications that would have moved through without issue in prior years, and in some cases issuing notices of intent to revoke, meaning the agency wants to withdraw a previously approved petition. For those on an H-1B waiting for a green card, the priority date cutoffs that determine when you can actually file for adjustment of status are no longer moving in a predictable direction. The visa bulletin has become increasingly difficult to interpret because the underlying demand data is being recalculated with new assumptions, particularly for Indian and Chinese nationals. The employment-based second and third preference categories remain decades backlogged, and new policy pressure on employer sponsorship is causing some companies to quietly reconsider whether they will continue sponsoring cases at all. H-1B. Renewals are no longer automatic. Here is something I want to make absolutely clear at U.S. Green Card Signal because I hear from too many people who do not realize this until it is too late. Even if you believe your case is secure, there is a significant hidden change unfolding right now in how specialty occupation is being defined for H-1B purposes. The administration has not passed new legislation, but USCIS has quietly updated its internal adjudication guidelines to apply a more restrictive interpretation of what jobs qualify as specialty occupations. IT consulting roles, certain business analyst positions, and jobs where the degree requirement is considered flexible are being challenged at substantially higher rates than before. H-1B renewals, not just new petitions but renewals, are being denied or receiving requests for evidence at rates significantly higher than just a few years ago. If you are on an H-1B and your renewal is coming up in the next 6 to 12 months, please do not assume it is routine. Speak with a qualified immigration attorney before you file. The cost of that conversation is a fraction of what a denial could cost you. Please note, nothing in this video constitutes legal advice. Please consult a licensed immigration attorney for guidance specific to your individual circumstances. OPT and STEM. OPT, a legally contested space. Let's talk about optional practical training and STEM OPT, the pathway that allows international students to work in the United States after graduation. This program has been a target of policy attention for years, and the situation right now requires your full attention. There are currently active legal challenges to the STEM OPT extension program. The administration has signaled that it views the program as an overreach of executive authority. A court ruling, which could come with very little notice, could change the situation for current OPT and STEM OPT holders rapidly. The administration has also made changes to how I-20 documents and SEVIS records are managed. There have been documented reports of SEVIS terminations being triggered by minor administrative issues that would previously have been resolved quietly between the student and their designated school official. When SEVIS is terminated, F1 status is technically voided, which means your OPT authorization, your presence in the country, and everything dependent on that status becomes legally precarious. If you are an international student, maintain flawless records with your DSO. This is not the moment to be casual about any paperwork. Legal status is no longer a guarantee of safety from enforcement. I want to say something that most channels will not say directly because I think you deserve honesty. The way immigration enforcement and immigration policy interact right now is creating situations where people with technically legal status are still being caught in enforcement actions. Understanding how that happens is critical. The administration has dramatically expanded the definition of interior enforcement priorities. Previously, immigration enforcement inside the country was largely focused on individuals with criminal records or final orders of removal. Now, enforcement actions are being carried out against a much wider population. people with pending cases, people with expired but technically still active petitions, people in removal proceedings who had previously been given informal deferrals. Operations are happening in major metropolitan areas, workplaces, and in locations that previously had informal protection policies. The geographic scope has expanded well beyond border regions. Here's the detail that most people do not fully understand. You can be in the United States with a pending application, technically authorized to be here, and still be detained if an officer makes a judgment call that your documentation is insufficient or questionable. Immigration attorneys across the country are documenting clients who have been detained despite having valid work authorization or pending adjustment of status cases. The system is not making clean, careful distinctions right now. Please take that seriously. Green card holders, the most dangerous misconception. This is one of the most important things I want to address at U.S. Green Card Signal, because it is a misconception I hear constantly. If you have a green card, you are not automatically protected from everything that is happening. The administration has expanded the grounds on which lawful permanent residents can be placed in removal proceedings, public charge determinations, old minor criminal records that were never previously considered deportable offenses, technical violations in the original green card application process. All of these are being revisited. There are cases working through immigration courts right now where people who have been green card holders for 10, 15, even 20 years are facing deportation proceedings based on issues in their past they believed were long resolved. If you are a green card holder and you have any question, any at all, about anything in your immigration history, a prior visa violation, an arrest even without conviction, any use of public benefits, please consult with a qualified immigration attorney before you travel internationally. Re-entering the United States as a green card holder is a moment when Customs and Border Protection can place you in secondary inspection. The standard of review has shifted. What was once a routine return home can now become something very different. Naturalization, the most powerful protection available to you. Let me speak directly to anyone who is eligible for U.S. citizenship and has been putting off the application. The distance between being a green card holder and being a U.S. citizen has never felt more consequential than it does right now. U.S. citizens cannot be deported. Their status cannot be revoked. They travel freely, and they are not subject to any of the enforcement dynamics we have been discussing. If you are eligible to naturalize and you have not filed yet, this is the single most protective step you can take for yourself and your family. I understand there are reasons people delay: cost, time, emotional ties to birth citizenship. But from a pure immigration safety standpoint, naturalizing is no longer a paperwork formality. It is a shield. The naturalization process itself has also shifted subtly. The civics interview is being conducted with greater rigor. Background checks have been extended. New administrative requests are being issued in naturalization cases involving travel patterns, tax history, and social media activity. None of this means you should not apply. It means you should apply with thorough preparation and, ideally, with professional guidance. 3 steps to take right now. Here at U.S. Green Card Signal, Edward and the team always want to leave you with concrete, actionable guidance. Here are 3 steps that apply regardless of your specific immigration status. First, gather and organize every immigration document you have. Every approval notice, every travel record, every I-94, every receipt notice. Keep both digital and physical copies in multiple secure locations. If you are ever detained or questioned, having organized documentation immediately accessible can make an enormous difference in how that situation resolves. Second, know your constitutional rights and be ready to use them. Regardless of immigration status, you have rights in the United States. You have the right to remain silent. You have the right to refuse a search without consent. You have the right to speak with an attorney before answering questions from immigration officers. Knowing these rights and actually exercising them in a moment of stress are two very different things. Think through what you would say and do if that situation arose before it does. Third, if your case has any complexity at all, invest in a professional consultation now, not when something goes wrong. A prior immigration issue, a pending petition, a criminal record of any kind, any gap in status, all of these warrant a conversation with a qualified immigration attorney right now. The landscape is changing faster than most people can track independently, and the cost of professional advice is a fraction of the cost of a serious mistake. Closing thoughts from Edward at U.S. Green Card Signal. Here is something I want to be honest with you about before we close. Immigration policy has always been political. It has always shifted with administrations. But what makes the current moment genuinely different is the speed, the breadth, and the heavy use of administrative rather than legislative mechanisms to drive change. That means the rules can shift without Congress voting. It means a directive from an agency official can change how your case is adjudicated. And it means that what was accurate about your situation 6 months ago may no longer be accurate today. That is precisely why U.S. Green Card Signal exists. Edward and the team track these changes in real time, translate policy language into plain English, and make sure you understand what it means for real people in real situations, not just in abstract policy terms. If this video gave you something genuinely valuable, a new understanding, an action you are going to take, a question you are now going to ask your attorney, please engage with it. It helps this information reach more people who need it just as much as you do. Leave a comment below with your visa type or your situation. Edward reads them. And the most common questions shape the content U.S. Green Card Signal covers next, because this channel exists to address what actually matters to you. If you are not subscribed to U.S. Green Card Signal yet, subscribe now, because the next video in this series goes deeper into a specific change that almost no one is talking about, one that affects a category of visa holders numbering in the millions. Your status, your future, your family, it is worth staying informed. This video is intended for general informational and educational purposes only. It does not constitute legal advice and does not create an attorney-client relationship. Immigration law is complex and highly fact-specific. Please consult a qualified, licensed immigration attorney for guidance specific to your individual situation. Thanks for watching. Stay informed, stay protected, and we will see you in the next one right here on U.S. Green Card Signal.